Good morning and welcome to the new frontier where we attempt to add just another grain of information to the vast ocean of knowledge that is the internet, especially as it relates to public policy. And today we have an especially controversial video, and that is a video about Senate Bill 90 in Kentucky. Now, this bill attempts to provide religious exceptions for certain healthcare service providers. So we've seen religious exceptions from healthcare services, but never religious exceptions to provide healthcare services. The difference is, this bill really poses one question. While written generally, do Christian doctors in specific, have to perform abortions or other services that conflict with their religious beliefs and values? Now, this has not been up for debate recently. We did, however, see a case in 2017 where Donald Trump actually was working on a case. President Donald Trump had heard about a nurse in Tampa Bay that was working at a healthcare center that had been discriminated against because she was pro-life. She did not want to perform certain services or suggest certain services, and President Donald Trump enacted legislation that protected from discrimination healthcare service providers who were attempting to not perform certain services based on their religious rights. Then in 2018, this was tested again in Masterpiece Cake Shop versus Colorado Civil Rights Commission, where famously the Masterpiece Cake Shop denied the service of a gay couple to make them a cake that was related to their wedding, or their wedding cake, because they did not believe in gay rights or gay unions, or that two men or two women should be married. Now again, in 2020, we're facing a similar issue. You might ask, how could we face a similar issue? It's already both in law and supported by the Supreme Court that a private business or a private service provider could deny someone services based on their religious beliefs. Well, a senator, specifically Republican Senator, what is his name again? Stephen Meredith, he decided to bring the debate back up by asking to codify this law in Kentucky's legislation, stating that while it may be national law and already protected by the Supreme Court, let's also make it part of our law as well, that there will never be a healthcare service provider or healthcare payer who is discriminated against or faces any form of liability, whether it be criminal, civil, or financial penalty, for denying services based on religious beliefs. Now, while it was thought to be controversial, we all know this is a controversial concept, most people thought really the issue had been resolved. But Planned Parenthood groups and other groups that we'll be talking about in Kentucky spoke up against the bill and said, no, this is a bit too far. In fact, if we allow religious doctors who maybe don't agree with abortion not to perform abortion, and also don't force them to recommend abortion services, there may be people who go without services altogether. So that's the debate we're working with. I'm going to give you more in-depth opinions about both sides of the issue, but not without first walking through the bill itself. So as we talk about here, most legislative change occurs right in the definition section of legislation. And they always make bills look so complex and complicated, especially with small font and underlines and all these like keys that you need to figure out. But really, this bill is easy to read, short, and attempts to define some what I thought to be undefinable terms, like someone's conscience. But this bill is about whether or not you can deny services based on someone's religious values or their conscience. So it only makes sense that the Kentucky Senate would try to define it. So they believe a conscience means any religious, moral, ethical, or philosophical beliefs or principles held by any medical practitioner, healthcare institution, or healthcare payer. Conscience with respect to institution, entities, or corporate bodies as opposed to individual persons is determined by references to that body's governing documents, which would include philosophical guidelines, directives, mission statements, articles of incorporation, bylaws, and regulations. The reason I highlighted that last part is that they're saying that if it is ever litigated that someone's religious beliefs need to be questioned, which the court typically does not do, they try not to touch that topic with a 10-foot pole, the documents they would use would be guidelines, philosophical guidelines, mission statements, moral and ethical codes, which for Christians would be the Bible, other religious groups, their religious texts as well, which would clearly give a Christian the necessary support they need in court to defend themselves if they ever do decide to deny someone abortions or any healthcare service provision at all that would, go against their religious values. It also states essentially that there needs to be actual support within your religious backing to support denying services. That means that there can be no arbitrary provisions that you're denying someone services for some reason you just don't like it. You're not going to give somebody, a crazy ear piercing or split their tongue or something based on your religious beliefs. I know both those surgeries aren't usually performed by doctors, but there would be no religious exception for that as far as I can imagine, having read the Bible numerous times. Then we also have to define healthcare services to know what can be denied. So what would fall under the category of a service that could be denied based on religion? And that would include, but is not limited to, examinations, testing, diagnosis, referral, which is really the one that many groups hit on, that this bill goes too far because it prevents even the referral of someone to an abortion clinic. It's one thing not to perform it, but to not refer it could endanger somebody. That's what one side thinks. Dispensing or administering any drugs. We've seen this before in another famous court case where religious groups, especially I believe it was the Catholic Church, did not want to provide contraceptives. And Obamacare at the time wanted to force contraceptives to be provided by Catholic institutions that do not believe in taking contraceptives. And the court again supported those religious groups, saying that you could not force them to provide a service that goes against their religious values. So now we have 3 instances where this has been supported on a federal level. Medication or device, psychological therapy or counseling. We've talked about this numerous times, but in another format. So most states right now are attempting to ban things like conversion therapy, which would fall under this category. But here we're actually trying to make it okay to deny certain services. So in effect, this would actually say support maybe LGBTQ groups that did not want to provide transgender or any form of conversion therapy to their individual employees. They would be protected in doing so if they have supporting documents that would govern the reason for denying this. Research, prognosis therapy, any other care necessary. So this is really a catch-all. Anything that could fall under the category of a healthcare service, even mental counseling and referrals would fall under this bill. One more definition I want to get to before we get into the meat of the bill, which is actually fairly short for this 5-page bill. Most of the changes made are right in the definition. What does it mean for someone to participate in providing healthcare services? Because in litigation, if someone were to be challenged for denying a certain service, one of the first questions that comes up is going to be, well, what do you mean by providing? What do you mean by participating in certain legislation? That could mean a lot of things. Is referring someone to an abortion clinic really participating? Is referring someone to conversion therapy really participating in the healthcare service? Well, Kentucky's Senate is attempting to define that as well, noting that participation means to provide, perform, assist with, facilitate, refer for, counsel for, consult with, regard to, admit for the purpose of providing. Everything you could imagine, even back again to referring for healthcare services like abortion. Very specific with the referral. I'm surprised it's in there, but that is really the purpose. Does a Christian doctor have to provide or refer a patient to an abortion clinic, or can they deny doing so because of their religious beliefs? The bill itself, the purpose, we're going to start with that. It's cited at protecting healthcare providers and professionals rather than denying healthcare. So that's what the bill is attempting to do. Protect healthcare providers from discrimination while still providing healthcare and not denying it to anybody. Mainly the sentiment comes from the opinion that healthcare treatment desired can be sought elsewhere. We live in a capitalist society, so if you want a certain healthcare service that your healthcare service provider will not provide you, there are other people in the market that will provide it. With that sentiment in mind, historically, it has been insanely difficult to argue that the Constitution could ever be used to force someone to do something. So this is where it gets tricky. I'm sure there are a litany of groups that want to speak up about or against this bill. The difficult part is how. How would someone speak up against a bill that's just attempting to make sure no one's hand is forced? If a court said that they were going to force an artist to paint a picture of some particular thing, you may wonder, well, how's the court going to guarantee that it's good? Or that what is painted is actually what is desired? In creative arts, it's nearly impossible for the court to force somebody's hands. But in something as complex as surgical or healthcare services, it gets almost as difficult as art. And the court would be nearly as pained to force someone's hand in this category. How could you make a Christian doctor provide an abortion? Would a judge stand over them? Would there be penalties if they did not? How could we guarantee that it was done properly? Things of that nature. Now, religious arguments get even touchier. Can you force Christian doctors to provide abortions? So we see how this gets harder and harder to speak up against. But groups have come up against this bill. Specifically here, the Kentucky Mental Health Coalition and Planned Parenthood groups in Kentucky opposed the legislation out of concerns that this could be a slippery slope to creating an atmosphere which certain treatments no longer exist or are denied for major portions of the population because of the high number of Christians in Kentucky. Without a referral system, it could also mean that people are denied services entirely because they don't know certain things even exist, that there are options available because they are not getting the information they need as a whole. So those are the two opinions, and here's the bill itself. A medical practitioner, healthcare institution, or healthcare payer shall have the right not to participate in or pay for any healthcare service which violates his or hers or its conscience, and that no medical healthcare institution or healthcare payer shall be subject to discrimination in any manner as a result of his, her, or its decision to decline to participate in healthcare services on the basis of conscience. So the bill's simple, the arguments are complex. Doctors would be protected for denying certain services and also would not have to refer for services that violate the religious exceptions. This type of bill is something that's going to be trending across the states. While federally laws are already in place to protect this very type of legislation, this opens up the door for groups like Planned Parenthood and the Kentucky Mental Health Coalition to relitigate this issue once again. This is almost like that one more opportunity to litigate Roe v. Wade, which we hear about all the time. It's like, what bill will be passed that will attempt to push just a little bit farther so we can get this back into the Supreme Court? This is one of those bills which could be challenged and once again be heard by a major federal court. So it's likely that other states are going to jump on board as well. This means that you need to really analyze this bill and ask yourself whether or not it should be allowed that doctors can deny services based on their religious values, and or should those doctors have to refer people to services or at least provide them the information of services that may not correlate with their religious beliefs. If not, why? If so, why? And let your legislators know. I always end the video with just a little brief that this is a representative democracy in America, a republic. The only way it functions properly is if you know enough about public policy to provide your legislators an opinion in which they can represent. This bill is definitely one worth studying, so you can write into your legislators, your state reps, your state senators. That's really where the change is going to be made, especially related to this, because federally the issue is not an issue anymore. And let them know what you think about this type of legislation. And tell them you either want bills like this or you don't want bills like this in your state. And if you do happen to live in Kentucky, make it known how you feel about this bill. State representatives and state senators have very small constituent bodies. That means your voice has a lot of power, especially as it relates to this decision. Let me know what you think about the video as well, and if you have any questions, ask them in the comments. I'm always happy to help. Thanks, guys.